Hello, everyone. Welcome to day 3 of the Towards the Lunar Generation workshop. This would be our third keynote today, which would focus on legal and policy issues of lunar resource utilization and infrastructure development. Our speaker today is Mark Sandel. He is a professor at Cleveland Marshall College of Law, where he teaches international business transactions, commercial law, space law, and ancient Athenian law. He's a leading expert on the law of outer space and focuses primarily on the business, legal, and policy issues arising from the recent increase in private space activity, like what we saw this Sunday. He's a member of the Commercial Space Transportation Advisory Committee, which advises the Federal Aviation Administration regarding new regulations governing private space activity. He's also a member and former Assistant Secretary of the International Institute of Space Law, and was a member of the UNIDROIT working group that was charged with drafting a new international treaty on the finance of satellites and other space assets, which is called the Space Asset Protocol to the Convention on International Interests in Mobile Equipment. So a lot of experience in this field. And today we will be listening to Mark about how space law basically applies to the moon. Mark, the floor is yours. You're on mute.
Ali, thank you for the introduction. It's an honor to be here to speak about the lunar generation, which is the generation of the next series of space lawyers, policymakers, lawmakers, engineers. We need people in all the teams in order to make this new generation and this new goal of colonizing, settling the moon reality. I want to quickly correct one misperception, and that is that I'm still a member of the ComStack. I was a member of the ComStack for several years, which is the Commercial Space Advisory, Commercial Transportation Advisory Council for the FAA. I'm no longer a member there, but I am advising NASA as a member of their Regulatory and Policy Commission. So when it comes to government advising, we frequently shuffle the deck. With that said, it's great to be here, and I spent some time brainstorming about what exactly the purpose and the nature of my presentation today would be. And there are many things to discuss. There are many technical issues, there are many specific issues in space law that are being debated right now around the world, both on the domestic and the international level. And we could have a technical discussion about any one of those issues. But instead, I thought that I would give a different kind of talk today. A kind of talk that you don't really hear that much about, and that is what the new generation of space law is going to look like. And so I've entitled this presentation, Shattering Paradigms, Possible Futures, and the Next Generation of Space Law. So what paradigms are we going to shatter? What possible futures am I talking about? Well, let me start by praising and celebrating the existing structure of space law that we have. Space law is not a new field, although it is a cutting edge field and hyper modern, but it's not a new field. We've had space laws on the books on the international level for some 60 years or so. And so we have established space law. And not only do we have established space law, and this is through the 4 broadly ratified multilateral treaties that were drafted under the auspices of the United Nations. Not only do we have these treaties, but they're very good treaties. We have excellent space law in place, starting with the Outer Space Treaty. And we need to recognize that in order to move forward, because there are certain things that we should be very protective of. And maybe that's one of the first considerations when talking about the creation of the next generation of space law, is that we want to be very respectful and protective of the excellent laws that we have in place currently. Perhaps the best example of that is the Outer Space Treaty's prohibition on positioning weapons of mass destruction, nuclear weapons and other WMDs in orbit. Or there's also a prohibition under the Outer Space Treaty for stationing military bases on the moon or other celestial bodies. And there is this overall concept under existing space law that we are to use outer space exclusively for peaceful purposes. Now, a very wise space lawyer once said in my presence, I was listening to her speak, and that is Professor Joanne Gabrinowitz, formerly of the University of Mississippi, that we should be very careful when talking about creating a new generation of space law. Let's be very careful that we do not upend or damage the extraordinary laws that we have in place already, and most particularly this prohibition on weapons of mass destruction. Be very careful if you're talking about replacing the Outer Space Treaty, because there's no guarantee if we were to enter open discussions regarding either the amendment of the Outer Space Treaty or the drafting of a new treaty, there's no guarantee that we would be as successful as we were in 1967 when drafting the Outer Space Treaty, that we'd be as successful as that in creating this important, this fundamental arms control aspect of the Outer Space Treaty. That in and of itself is reason enough to keep things as they are. But we know that we can't keep things as they are forever. We are evolving, developing at an extraordinary rate. Just this weekend, just 2 days ago, we had Sir Richard Branson fly into suborbital space, an event that we've been waiting for some time, since Scaled Composite, the company that originally held the rights to Spaceship One's intellectual property. It was 2004 when Scaled Composites won the X Prize by delivering human beings into suborbital space twice within a 2-week period. So we've been waiting for all that time. What is that, 16, 17 years? These things take time, they're very challenging, but Richard Branson did it. And now we are officially in a new age of commercial space flight, private space flight, that will achieve both suborbital space, but also orbital space. SpaceX is, as we all know, been doing extraordinary things to shift the paradigm, shift the engineering paradigm of space travel so that the access to space is cheaper by orders of magnitude. And that kind of shattering of the engineering paradigms is what we eventually will be called upon to do as space lawyers, to shatter the existing paradigms and recreate space law as will be needed in the new era that we are just now entering into. An era that will be marked by not only private citizens flying into suborbital space or flying to private space stations, but also eventually to the moon and to Mars. I assume that you know about the plans of a Japanese billionaire to circumnavigate the moon on SpaceX's Starship in the foreseeable future, within the next couple of years. So these things are happening, and they're happening quickly. So what paradigms am I trying to shift? What paradigms am I talking about shattering? Well, there are a number of places, if you've been around space law enough, and you've witnessed these dramatic changes, this dramatic evolution of space technology. If you've been watching this long enough, you do notice that there's some stress that is placed on existing space law. And those stresses have grown greater in a time of expanded commercialization of outer space, and they will continue to grow greater. And at some point, although now we're talking about in the many multilateral discussions and private discussions of space lawyers, frequently we shy away from the discussion of a new treaty or any kind of radical reformation of space law. Well, on the one hand, because we have such excellent laws in place. But on the other hand, due to the political reality that is accepted by many, the political reality that it's very difficult to get 100+ nations on the same page and able to agree on new laws and new rules for how we will govern space activity. So the political reality, the difficulty of achieving treaties has dissuaded people from talking about shattering paradigms and creating a new generation of space law. But at some point, that political will, that political reality will also change. And that brings me to a question: what will it take? If we know that there's a need for the reformation of space law, what will it take? But before I go there, let's talk a little bit about where I see these stresses under existing space law, the Outer Space Treaty, the following treaties, international treaties that elaborated upon the duties, rights, and obligations of the Outer Space Treaty. Why are these laws not sufficient as they are anymore? Why are they starting to show their age? Well, I've got a long list here. And these are the challenges that I present to you, the new generation of space lawyers, to consider and try to solve. As an aside, lawyers are bound by tradition. We're traditionalists in the general sense. Legal education is a very traditional process. At least here in the United States, it has barely changed for 100 years, maybe around the edges. We have some new curriculum, some new courses, maybe a new focus on this skill or that subject matter. But by and large, the process for educating a lawyer has remained the same through all these years of technological and societal development. And so we have within us kind of inbred a sort of aversion to radical thought or action. Lawyers are generally risk averse, right? They want to make sure that their clients do not suffer from any inordinate risk. Don't like change. We don't like risk. And if you look at the succession of space lawyers, we see a continuation through the ages, just like legal education has not evolved much. We see a clear line of succession of space lawyers. It reminds me of going to my, Ali mentioned my interest and training in ancient law. It reminds me of the succession of philosophers, beginning with Socrates, who taught Plato, who taught Aristotle, who taught Theophrastus, and the list goes on. And I could recite a similar list of space lawyers, an illustrious bunch, and I'm very honored to be counted among their number. But we could talk about space lawyers from going back to the 30s, Vladimir Mandel. And then to the first generation of space lawyers that shaped the existing treaty structure that we have, such as Vladimir Kopal, to stay with the Vladimirs, or Eileen Galloway, etc. Cobb, these names start coming to mind. And we have also an illustrious a group of space lawyers now that are in the elder generation. And I may be a small step beyond that or earlier than that, but the room is starting to open for the next generation. And the point of all this is for me to call upon you to be daring, not reckless, but I think the changes, the greater paradigm shifts, the shattering of paradigms will likely not happen with me or my colleagues at my stage of the game, but it's going to happen with you, the next generation, the lunar generation. And I was asked to talk about lunar law, and we can frame what I'm going to say in the frame of lunar missions. Doesn't mean that these comments don't apply to other aspects of space activity, but lunar missions are presenting a great number of challenges to existing space law. Let me mention a few of these, because I always like to focus on the problem at hand. And I encourage all of you as young space lawyers, policymakers, pundits, to also be sure that you do that. Because we have enough real challenges facing the countries of the world, the space agencies of the world, the space industry, that we don't need to create new challenges. It's very important to focus our minds on the challenges that exist. And there are many of them, as I said. I'm going to take you on a short tour of some of them right now, but always focus on the problem. And also, if I can give one more bit of advice to young space lawyers, is understand the problem. Understand the technology to the extent that you need to really grasp what it is that we're trying to address. Understand what you're trying to regulate. And the failure to do that can lead to some rather embarrassing results. I don't remember exactly which year it was, but I do remember that the hallowed Manfred Lach's Space Law Moot Court competition once involved a hypothetical situation that contained physical impossibilities. And it's an excellent example of how space lawyers engrossed in our creative thought can give short shrift to the laws of nature or the physical realities at hand. So always understand what you're going to regulate. But with those tools in hand, right, focusing on the actual problems at hand, and then really understanding what it is you're trying to regulate. With those tools, I call on you to move forward boldly and try to reimagine space law. Let me go through some of these areas of space law where I think that change is due or will be absolutely needed in the coming years. Registration. We have a very successful treaty, the Registration Convention, and I and others have called it the most successful of all treaties, although most share that distinction for the Outer Space Treaty. It is our Magna Carta. But registration is one aspect that needs revision. And why is that? Because the Registration Convention contemplated the registration of primarily of orbital space objects, because that was primarily the concern at the time. That was the problem at the time. And the delegates of the UN focused on that problem. And resolved it by adopting the registration convention. But if you look at the convention, it calls for orbital parameters when describing the location of space objects. And the registration convention is limited to the registration of objects. Now we're going to the moon. And in order to preserve order and equity on the moon, we need more information sharing of different kind. It will be the geographic location of the moon that we need described on a registration of activity on the moon. And we need information, more detailed information about the nature of the activity. So we need to refine the way in which we register our activity in space. Liability. Liability continues under the Liability Convention to be attached and to be attached permanently to the launching state or launching states. And we already see that concept is experiencing some stress. And why is that? Well, when the Liability Convention was concluded, there was not, it may have been contemplated, it may have been predicted, but it was not an area of major concern that there would be a vibrant commercial market in buying and selling space assets, buying and selling satellites. And so if you sell a satellite, then the launching state is often no longer in control of that satellite. And it's unfair to have the launching state maintain liability if it's been sold off to some other entity that is not under the jurisdiction of that country. And so liability is showing stress and strain under the weight of all the new things that we're doing in space. Even the rescue and return agreement that requires the rescue of astronauts or personnel and the retrieval of crashed spacecraft and the return of them to the launching authority. What is the problem with this existing law? That it describes and it imposes an obligation to rescue personnel. And what is personnel? Does that expand to spaceflight participants, private passengers? It's unclear. It's another example. Even the definition of space object. Space object, which if something is defined as a space object, it brings it within the scope of existing space law, such as the Liability Convention, damage caused by a space object. But here lies a fundamental problem, that space object is defined as something that is launched into space. What if something exists, a man-made object exists in space that was not launched from the Earth? It was created from mined materials that were then processed and formed into an object. Is it no longer a space object? Mega constellations, this new technology that will blanket the Earth in tens of thousands of satellites, and there are multiple projects that are underway to do this, most notably Starlink, that is being put into orbit by SpaceX. These mega constellations, we've never faced this before. Now, the US licensing agencies have been granting licenses in order to operate, launch and operate these mega constellations. But do we really know what it is that we are approving? There have been problems with astronomers already, but can the low Earth orbits handle satellites in that number? Or will we see collisions, the creation of more space debris will become a problem? So we don't really have a good answer for that yet. Heritage sites. Is there any protection for the lunar landing sites or the sites on the moon where the first Chinese landing took place or the first rover was set down? Are we to protect every footprint? Are we to protect only certain historical sites? How do we determine that, and how do we make the decision? I have to say that the Moon Village Association, you are in the right place, because I believe, and this is arguable, but I believe that the most important conversations going on right now with respect to the future of space law are happening under the auspices of the Moon Village Association. The GEGSLA, the Global Expert Group on Sustainable Lunar Activity, is in full swing under the leadership of our president, Giuseppe Ribaldi. And so you're all in the right place. We're talking about heritage and how those special sites should be protected. But we have we do not have sufficient law yet, although there has been some movement in the United States, at least due to the efforts of For All Moonkind. The definitions of certain space law terms, which are vague, as many legal terms are. That's why we have lawyers and need lawyers, and this is why we need you, the new generation of lawyers, to begin to disentangle and clarify existing law. One of my favorite new words these days is one that's been used quite frequently in these discussions, and that is operationalization. I said it, I was a little nervous there for a moment. Operationalization, I did it twice in a row. And what we're talking about is operationalizing existing law. We know the law, we have it, it's longstanding law. For example, the obligation that all parties engaged in space activity carry out that activity with due regard to the corresponding interests of all other countries. We're well aware of that law. We respect it. We want to abide by it. I think everyone wants to be a good citizen in space. The problem is we really don't know what it means. What does it mean to operate with due regard when you're landing on the moon? Does it mean that you are to ensure that your landing takes place no closer than 10 kilometers to the nearest Apollo landing site? Is that what it means? Again, the importance here of understanding what it is you're trying to regulate. Do you really understand how lunar dust flies? How long it takes to settle? What the risks are to operating machinery posed by lunar dust? This is where we need the expert assistance as lawyers. Don't be afraid to ask for help. Ask for help from the engineers and the physicists that are there to work together with us to draft and implement reasonable rules. So due regard, that's another area of space law that needs attention, needs clarification. Another is harmful interference. As you all know, who've studied space law, there is a duty to consult with the affected party in the event that there is a possibility of harmful interference. So if you are landing on the moon and you believe that some dust may fly towards an Apollo landing site and may cover existing footprints, now we have combined issues, complexity. One, is there any duty to protect those heritage sites whatsoever? And if there is there a risk posed by this lunar landing? You see the problem. So harmful interference. What rises to the level of harmful interference? Is it that it simply requires another party to maybe take protective actions and protect their equipment against lunar dust? Or is there a higher level or a lower level? What is harmful interference? Is it just inconveniencing other parties, or is it causing irreparable harm, serious irreparable harm? We haven't clarified that exactly, and we need to do that as we move forward. Moving away from the moon, because I think it's fresh on all of our minds, but suborbital space tourism. As you may know, we have laws and regulations here in the United States that govern suborbital commercial spaceflight, human spaceflight, and it exists in other countries as well. But it's a very, should I say, it's a very early form of regulation, which is entirely appropriate. And this isn't a criticism. The existing regulation for suborbital spaceflight is that the spacecraft have an atmosphere that will support human life. Now, if you're talking about a low bar, you can't set it much lower than that there will be oxygen on board and that the passengers will survive, at least due to the nature of the atmosphere. The existing regulatory system is actually a system of informed consent and the assumption of risk on the part of the spaceflight participant. And that is necessary in this very early stage industry. We do not want to smother these industries with extensive design requirements and safety regulations, but eventually that day is going to come. And you all need to start thinking about what is the appropriate level of regulation when suborbital space tourism becomes a regular occurrence and when we begin point-to-point suborbital space travel. Now, we're going to face this issue relatively soon. You know, not only is are the operations evolving in Virgin Galactic and other companies that will follow, but the law calls in 2023 for a moratorium that has been placed on the creation of safety requirements in the US. In 2023, that moratorium will be lifted. And so the FAA will have then the authority and power to move forward and enact further regulations. Do we want to? Is it time? And what are those regulations going to look like? So there are all of these issues, actual, real issues in space law that are going to need some kind of refinement. And at some point, it's going to take more than simply an understanding between countries or the establishment of best practices. At some point, we are going to have to move forward beyond our existing structure of treaties, beyond the very light regulatory touch, and we're going to have to draft a new generation of space law, a new generation of treaties. You know, one issue that I failed to mention, probably because it's one of the more obvious ones to mention, is resource extraction. I think we've come to the point where resource extraction is acceptable and deemed legal, but there will be a lot of questions, legal questions, as we move forward and actually create a mining industry on the moon and other celestial bodies. So you see that is going to need some attention as well as we move forward. Maybe not quite yet. I'm not calling for any radical changes at this point. I think we continue as we birth these new industries to do so cautiously with a light touch. But eventually, since I'm talking to you, this is a futuristic conversation, there will be the opportunity soon to make some more groundbreaking, paradigm-shattering changes. And I look forward to seeing what your generation does. Now, with that in mind, the next question is, when are we going to do this? When are we going to address these legal issues? Will it require a disaster? Will it require a war over natural resources on the moon before we come to an understanding and an agreement about how we're going to conduct these operations in line with our obligations of due regard and avoiding harmful interference? Is it going to take a war before we overcome the stalemate in the United Nations and actually draft the laws that are going to be needed? I hope not. That would be the worst case scenario. Is it going to require accidents on the, for example, the suborbital tourism level before the FAA steps in and starts imposing safety requirements? Let's hope not. But that is the difficult balance. That is the difficult calculation to make. No one wants an accident. No one wants a war. And also no one wants to move rashly and to begin to promulgate rules and regulations that will stifle an industry before they're needed. So we know we need to address certain issues. We're cautious about moving forward, but we know we need to move forward, and we don't want to wait for an accident or a war. I'm going to end my talk with, if I haven't been already, as kind of free thinking and forward looking and philosophical already. Let me get philosophical now. Your generation, as we move from a nascent spacefaring civilization to a multiplanetary species, your job will be facing the opportunity to remake, in certain ways, human civilization. And that will be your challenge. We are going to move to the moon. We are going to have a permanent human presence on Mars. We are going to expand throughout the solar system. And when we do, are we going to take with us all of the frailties, defects, darkness of the past several thousand years of human civilization marked by war, crime? Or are we going to move forward into the solar system with a more optimistic view of human nature and with rules and practices in place that will protect the solar system from our darkest impulses? Is it possible that we will, from this point onward, use the solar system exclusively for peaceful purposes? Well, that will depend on you, how you and your generation interpret the word peaceful and what you add to the existing body of the law of outer space. So with that, I'd like to end my remarks and open up the conversation. I'm glad to take any questions.
Thank you, Mark, for the great talk. We already have one question, actually. So I'll start with that. What happens with traffic management as we increase the number of players that are sending objects out towards the moon?
Yeah, yes, right. Good question. What happens with traffic management? It's certainly a very hot issue that a lot of people are paying attention to. We do not want collisions. So I think we will continue to expand technological and bureaucratic capabilities to manage space situational awareness and share that information. But we're going to need to keep honing our capabilities, and there's been movement in the United States to transfer those responsibilities from one agency to another. Hopefully that will be successful, and we'll see. But of course, it's one of the great problems that is posed right now.
And another question, this kind of came out of a discussion yesterday in one of our discussion groups. So some countries have national laws that kind of are focused on let's say lunar resources or topics like that, and obviously we're talking also about international law. So how do these interface with each other, and kind of does that create new challenges in the future as we move to send more people and more companies and organizations to the moon?
Yes, domestic law is where it's happening these days. If you haven't noticed already, because of the, as I call it, the stalemate in the United Nations, the aversion to seeking a binding treaty, the action has instead been at the domestic level. And of course, sometimes that's been controversial. It's controversial in the United States, passed the Space Resource Exploration and Utilization Act to legalize the ownership of space resources. There is going to be some a give and take. There will be countries that push the envelope, as the United States did, and Luxembourg has, and now other countries. So I think that it will be healthy in a sense. I think the experimentation will be taking place, and the evolution will be taking place on a domestic level. So it may be, very interestingly, sort of a bottom-up approach to international rulemaking if we see these rules adopted first on the domestic level, until the international community has no choice but to recognize that this should be international law and international practice as well.
Alexandra asks, aerospace as an industry has largely been reactive. Regulations and caution enacted after accidents and disasters. What do you see as the challenges to shifting the paradigm without stifling the needed risk to advance exploration?
Yeah, that's the dance that I was talking about, the dance between, knowing that there has to be increased regulation at some point, but not wanting to introduce it too early. And so we do have a great deal of data about spaceflight that goes back decades. But I don't have an answer to how that is going to come out, except that it should be, and this is another important lesson, I think, for everyone to internalize, is that whatever is done with respect to the suborbital tourism industry and its regulation, it should be done hand in hand with the companies. And nothing should be sprung on these companies, which then could have a devastating effect on their operations. So whatever is done, it should be done in close consultation, as the U.S. government frequently does, and I encourage that approach around the world.
Joe asks, what do you think are the opportunities and limits of soft law approaches that seek to provide norms of behavior or customary approaches that will precede developments in treaty law? Specifically, what do you make of the Artemis Accords? Are they a break with tradition?
Interesting. That's a great, I see you're following me in my theoretical thought here. Yes. Yeah, what are the limits of soft law? Because we have kind of lost faith in the creation of binding hard letter, black letter law at the international level, we find ourselves always moving in the direction of soft law, guidelines, best practices, model laws. But what is the limit? It's good, it's better than nothing. And we have a lot of that activity going on. But what are the limits of that soft law? It's a good question. We cannot, I think, abandon the desire to create something that is harder, that is more binding. But in the meantime, it's really all we have. But I take that point. I think it's a good point. we cannot be complacent and simply accept the fact that we have nothing but soft law to work with. There is a limit to its effect.
Mitchell is asking, would you please elaborate further on the rule of law? Specifically, I think there's tremendous skepticism that this argument of the insufficiencies of existing law as a fig leaf for the whims of power. I would like to preempt a possible response that the challenges of new circumstance threaten the rule of law in and of itself. There is a burden that later developments must conform to the rule of law and not the rule of law to new developments. So the question is really, what do you think rule of law is?
Yeah, rule of law, and yes, that's a great question, and I guess that's why we're all here today. But I see in that question also a sort of reference to political will of the major space powers and how they interface with the rule of law. There was the mention earlier of the Artemis Accords. I guess you could ask the question, do the existing space powers really want more binding law? Do they want to revise existing law? Or do they want to take other avenues towards establishing rules, such as the Artemis Accords? The Artemis Accords are binding, they are agreements, they are treaties, but they're bilateral treaties. And I'm certainly a proponent of the Artemis Accords. I think they do nothing but confirm existing space law and demand the confirmation and the adherence of existing space law among the participants in the Artemis program. And they make a good faith attempt to innovate a bit, for example, with the introduction of safety zones in order to address the real problems that our astronauts are going to face on the moon. But they have also been somewhat controversial and treated as if they were an unacceptable unilateral activity, but every country has the absolute right to enter into treaties. But I think that these agreements are done in a very responsible way, written by people with a great respect for international law.
Arun is asking, do you think large companies can end up being monopolies in the sector, which would later introduce laws that favor a first mover advantage that would stifle innovation for smaller companies?
Yes, I think this is probably, Arun is really thinking about resource extraction. And I was a member of the Hague Working Group on the governance of space resource activities. And there was a talk and a provision in the building blocks regarding the recognition for pioneers. That pioneers should, as the law is developing, there's a kind of a lack of clarity, we should give sort of special treatment to pioneers by recognizing the risks and investment that they took. And I think that is a point well taken. What exactly that means in practice isn't clear, but we do want to foster and nourish these pioneers. But of course, we want to guard against monopoly. We want to create a sustainable, competitive marketplace of companies that are engaged in that activity. So it's a good point. We want to protect and reward the pioneers, but we also want to prevent them from controlling the industry.
Lars asks, do you think the emerging US-China competition on technological decoupling will create obstacles for space policy and space law?
Oh, I'm so glad that you asked that, Lars. I meant to mention that. one of the concepts that I want everyone to keep in mind, all the young space lawyers out there as you move forward. Well, I mentioned it briefly, questioning whether we'll bring war with us and all of our darkest impulses into outer space. But more specifically, what does the current relationship between the United States and our allies and China and the apparent dual tracks that we're on, that we are not cooperating, that we are making our own separate ways to the moon and beyond. And on the one hand, when you phrase it as a space race, it can be very healthy and positive, a little healthy competition with the Chinese, never hurt anyone. But obviously there's a darker dimension to this, that this kind of failure to work together, this lack of cooperation could develop into something more sinister, could develop into future conflicts. And so we certainly want to avoid that. And an idea that I am floating these days is that, well, I think it's too late to decide on to have China join, at least at this point, the Artemis Accords or the International Space Station. The Chinese have had great successes on their own and have their own space station. But we should constantly look, I think, for opportunities to work together. Perhaps there could be a meeting between the Chinese and the United States on the moon for tea one day, or to have the orbital space stations a rendezvous, as we had the rendezvous in the 70s that was successful between the USSR and the United States. So in short, I want to encourage us all to use outer space as a laboratory for peace here on Earth and seek opportunities to work together in space, and then hope that that attitude will redound here to Earth.
And for our last two questions, I thought I'll actually ask you the same questions that our participants are right now trying to answer in one of our discussions groups. So the first one is, what are the main challenges and obstacles to a legal framework for lunar resources in your opinion?
The main challenges and obstacles, I think what is needed most is a registry of mining activities, and that is called for by the Hague Working Group Building Blocks, and is being worked on by the Registration Project, which is also happening under the auspices of the MVA, and the GEXLO will be taking up this issue as well. But I think we need a registry to make sure that everyone knows where everyone else is operating, so that we can operate with proper due regard, and that this doesn't turn into a competition over limited natural resources. There are a lot of problems to work out, such as, does registration bring with it priority? Can we, for example, will we be able to register mining operations in advance to, in effect, stake a claim and then exclude other countries from operating? This is very problematic under existing law. The concept of excluding anyone from anything on celestial bodies is anathema. And so how are we going to resolve these issues? I think that is going to be a big challenge.
The last question, Joe actually asked this. At some point, there will be a space law case that comes to national or indeed international prominence. What kind of case would you imagine this being?
I think we're going to see a liability case under the Liability Convention, that there will be damage caused by a space object of one country to the space object of another country, probably in orbit, particularly in light of these mega constellations. and there will be a collision. There have been in the past, but it hasn't resulted in a case. But at some point, there will be astronomical, to put it, damages that will make it necessary to resolve the issue. And so it would go to the ICJ on the particular issue. And this is another concept that needs to be clarified in space law, added to the list. It will be on the particular issue of whether or not the offending country is at fault. As you know, you are liable for such damage if you are at fault. What does that mean? What does at fault mean? And I suspect that that will be among the first cases that we'll hear on an international level.
Has this happened in the past, a case where the liability convention had to be kind of used?
Well, not directly, but we did have the, in the 70s, the disintegration of a Soviet satellite over Canada. And it resulted in the pollution by the, of Canada by the radioactive fuel of that satellite. And the Soviet Union did assist with the cleanup and pay for the costs of cleanup as would have been required under the Liability Convention, but it was done, as they say, in the shadow of the convention. Everyone behaved as they should have under the convention, knowing that if they didn't, they would likely be brought before the International Court of Justice. And we've had other collisions. There's an Iridium satellite that was destroyed by a defunct Russian satellite, but Iridium simply chalked that up to the cost of doing business. That's what insurance is there for. They have a spare satellite that was parked, that was quickly moved into position to fill the gap. And I think the litigation complexities of suing Russia for a defunct Soviet satellite would not have been worth the time and effort. So we've had some episodes, but nothing that directly addresses the issue.
I guess this brings us back to the question of basically the fact that states, in essence, are still liable for basically the assets that companies operating in those countries are sending to space. Do you think that would continue as we try to go towards the moon and other places?
Yes, the space law is extraordinary in this one respect, that it has this clear imputation of liability from private entities to the government. You know, where else do you see such clear imputation? I think nowhere else. And so I do think that we're going to have to revert to the more general rule eventually and not impute liability so clearly to states.
Perfect. And with that, I think we answered all the questions we had here from the audience. Thank you, Mark, again for joining us today and for the great talk. And thank you, everyone, for joining this call. Have a good rest of the day.
Many thanks. And I look forward to connecting with all of you at some point. And thank you again for the honor of delivering the presentation. Thank you, Ali, for an expert job in moderating as well.
Thank you all. Have a good day. Bye.